Earlier this week, there was a publicly held hearing in the Jones versus Abel case, which actually does not involve Blake Lively at all, but she had tried to insert herself into it in support of Stephanie Jones. The issue at hand was a motion to compel filed by Jones. She was seeking information from Katie Case, who used to work for Melissa Nathan at TAG. Katie Case is not a party to this lawsuit. The judge has now issued a ruling on the matter. Jones was saying that Katie Case had not produced messages, documents, materials, whatever, in response to a subpoena they had served upon her. They're saying that Katie Case, at the direction of Melissa Nathan, had something to do with this Stephanie Jones leaks, Stephanie Jones Lies websites, the Business Insider piece that came out, Who's Afraid of Stephanie Jones, and some disparaging Twitter accounts relating to Stephanie Jones. The Wayfarer parties had objected to some of the things that were in the subpoena. Although this has nothing to do with Blake Lively, she, again, is trying to make it sound like the Wayfarer parties somehow withheld evidence. Stephanie Jones Lies, Stephanie Jones Leaks, whatever, has nothing to do with Blake, nothing to do with her claims. But there is some pretty compelling evidence that Stephanie Jones and Blake Lively were working together under the table before these lawsuits were even filed. That goes back to Van Zandt, the shell company allegedly used by Blake Lively to obtain Melissa Nathan, Justin Baldoni, Jennifer Abel, all of their messages off of Jennifer Abel's cell phone in a way that wasn't really above board as far as the legal process goes. But Blake was saying that these documents that Jones is seeking, they should have been given to Jones and they should have been given to Blake Lively as well. And she's trying to enforce this subpoena that she did not serve in a case that she is not a party to. I don't want to rehash all the details right now. I did a video that was it's shorter than 10 minutes, kind of going over the background of what the issue is here. If you want to watch that, I'll put a link in the comments below. But Blake Lively said, Ms. Casey's recent apparent agreement to compile and produce documents to the Jones parties regarding or relating to any websites or social media posts concerning or relating to Stephanie Jones and or relating in any way to what ultimately became the Business Insider article. And here's where it's the stupidest part of this whole thing, now confirms that there are documents responsive to Miss Lively's document requests that were improperly withheld. What? Katie Case's attorney quickly popped in to say, hey, that's a bunch of bullshit, saying the central position of Miss Lively's submission rests on her counsel's assertion that Miss Case's prudential production of additional records confirms there are documents responsive to her document requests that were improperly withheld. That averment is incorrect. The assertion that because additional potentially responsive records may exist outside of those parameters, Miss Case somehow withheld records is thus untrue, as Miss Lively's counsel knows or should know. And here the Wayfarer parties pointed out how bizarre it was that she was seeking to compel compliance with a subpoena that Blake did not serve, and the motion to compel was filed by another party in another case, which she is not a party to. So the judge has now issued an order after that hearing Monday, denying the motion to compel filed by Stephanie Jones with Blake Lively riding on her coattails. Let's take a look at why that was denied. Now, mind you, Blake Lively really has nothing to do with this decision. She had no standing here. But Blake Lively and Stephanie Jones have both been trying to assert that the Wayfarer parties somehow deleted evidence. They've asked for sanctions for spoliation of evidence. Stephanie Jones' attorneys tried to bring this up in the hearing, saying that this further reinforces their assertions that there was evidence spoliation, which was actually really funny because Kevin Fritz, the attorney for Justin Baldoni and Wayfarer, had to step in and remind that attorney that the spoliation of evidence accusations, all emotions related to it, were filed in a different case, not the one at hand. Because remember, Jones versus Abel is a separate but related case. And again, if you want more background on what was going on with that subpoena, why they were asking for this, just go to the video I did the other day, which I'll link below. Stephanie Jones moves to compel non-party Catherine Case to produce materials in response to a subpoena dated October 17th. Although Case initially objected to the subpoena, she expressed a willingness to confer with counsel for the Jones parties regarding a supplemental production, and counsel for both parties subsequently agreed to the scope of such a production. The Wayfarer parties now seek to intervene and object to the production, arguing that the subpoena is untimely and that any request for an extension of the discovery deadlines should be denied. The court heard argument on the motion on November 24th. That was Monday. The subpoena seeks documents and communications regarding certain negative websites and social media posts. It was issued on October 17th, almost 2 months after document discovery for non-parties closed on August 15th. The Jones parties assert that they issued the subpoena in response to information obtained during the deposition of Case on September 5th, Melissa Nathan on September 30th, and Jed Wallace on October 10th. They contend that these depositions revealed that their prior subpoena to Case was inadequate to capture all relevant materials in Case's possession that bore on the disputed subjects of Case's, Nathan's, and Wallace's testimony. In particular, the Jones parties did not know that Case had written copy for the Stephanie Jones Leaks website and associated Twitter posts or for several other similar smear websites at Nathan's and Wallace's direction, nor that Nathan and Wallace would deny involvement in all such disparaging websites. So this was something that came up in the hearing, that they were saying, well, we didn't know that Melissa Nathan was going to deny involvement in this, so now we have to ask for other information, because there's conflicting stories here between Katie Case's story and Melissa Nathan's story. Fritz pointed out that in the Wayfarer party's responses to the claims, they actually did deny involvement. So they already knew that Melissa Nathan was denying involvement in the website. They knew this earlier, and they still failed to ask for this information. So Stephanie Jones serves this subpoena on October 15th. They agreed to a scope of supplemental production on November 11th, but then the Wayfarer parties noted their objection to the subpoena, citing proprietary and potentially other interests of our clients Tag and Nathan in the documents. Remember, Melissa Nathan is one of the Wayfarer parties, and some of this is relating to her business Tag, and the publicists especially don't want all of their business getting out there in the public in court if it's not totally necessary. I believe it was actually Stephanie Jones' attorneys who made a huge point of this in the beginning of all of this mess. As an initial matter, the Jones parties argue that Tag and Nathan lack standing to object to the subpoena because a party has no standing to seek to quash a subpoena issued to someone who is not a party to the action, unless the objecting party claims some personal right or privilege with regard to the documents sought. So here the judge actually does agree the Wayfarer party's conclusory assertions regarding proprietary and potentially other interests fail to establish some personal right or privilege with regard to the documents sought. That is especially true given that Nathan and Tag have expressly denied that any work Case did on the websites or social media posts was on their behalf, going so far as to suggest that Case's testimony to the contrary was perjurious. And in the exhibits I'm not going to go through right now, you can see in Jen Abel's deposition, they are asking about Katie Case testifying that Jen Abel had some sort of involvement, and Jen Abel says basically, yes, she's lying to you about that. So the judge did agree with that, but then he notes here the issue of the standing is separate from the timeline issue. So the subpoena violated the court's scheduling deadline for discovery by quite a bit. And he says the courts have indicated that that issue alone is an independent basis to grant the request to quash. He cites here a scheduling order is an order just like any other order of the court and may not be ignored or disobeyed simply because the parties agreed to do so or because one party lacks an interest in the documents sought. If the Wayfarer parties had issued a slew of pretrial Rule 45 subpoenas for documents and testimony well after the court-ordered deadline for discovery, the Jones parties would not have been powerless to present that violation to the court. The same principle applies when it is the Jones parties and not the Wayfarer parties who are seeking to enforce a subpoena issued after the period allowed for the issuance of such subpoenas. Service of a subpoena after the close of discovery is generally improper. Parties may not issue subpoenas as a means to engage in discovery after the discovery deadline has passed. A party must show good cause for the issuance of such a subpoena and thus for a motion to compel compliance with that subpoena. The Jones parties have not established good cause. They argue that their decision to wait to issue the subpoena should be excused because the full scope of relevant communications became known only on October 10th, after the completion of Case, Nathan, and Wallace's depositions. However, Case was deposed on September 5th, and the Jones parties would have been aware, at least at that point, that there likely existed relevant documents that had not been produced. Case testified that she wrote copy for the Stephanie Jones Leaks websites and other similar smear websites at Nathan and Wallace's direction. And remember, that's not a proven fact, right? That's just what she testified to in her deposition, a claim that they are vehemently denying, or at least Jen Abel is. At that point, at the latest, the Jones parties could have issued the subpoena. So that would have been over a month before the subpoena was actually issued. The Jones parties argued that Nathan and Wallace had not yet testified by September 5th, but that does not excuse their failure to timely issue a subpoena once they became aware of the existence of the documents. Nathan and Wallace denied any involvement in the creation of the websites, thus there is nothing that the Jones parties would have learned from their depositions about the likely existence of the documents that they did not already know from Case. Even if there might have been cause for the Jones parties to wait until after Case's deposition to serve the subpoena, the decision to wait an additional 6 weeks before doing so demonstrates a lack of diligence. The Jones parties' additional arguments fail to overcome this flaw in their good cause showing. They argue the Wayfarer parties will not be prejudiced by an amendment to the scheduling order because the court has not yet set a deadline for summary judgment motions. And remember, the summary judgment motion we saw was in the Lively case. This is a separate case. It's Jones versus Abel. So they don't have a deadline for summary judgment in that case yet, or a trial date. But that does not mean that the parties are free to continue to issue pretrial fax subpoenas up to the moment of summary judgment. The absence of prejudice alone is insufficient to show the presence of good cause. The court itself has an independent interest in compliance with its orders. It thus is not enough that the adverse party is unable to show prejudice. The Jones parties also contend that the Wayfarer parties' delayed and deficient disclosures throughout the course of discovery provide a basis for finding good cause, especially given that the Jones parties have also raised concerns regarding alleged spoliation, this is what I was talking about earlier, committed by the Wayfarer parties. That argument also does not answer the concerns of the Wayfarer parties and of the court. If the Wayfarer parties failed to produce documents they should have produced, then the Jones parties should have filed a motion to compel against them. And if, in fact, the Wayfarer parties have spoliated evidence, the remedy is spoliation sanctions. The Jones parties have failed to show that any discovery violations by the Wayfarer parties provide good cause for their failure to serve the subpoena earlier. Next, the Jones parties argued that they do not need to demonstrate good cause because case consents to the current production. It's true that parties and non-parties need not seek the extension of court-ordered discovery deadlines to exchange documents or to engage in informal discovery. A party may ask a witness for information and documents after the close of discovery, but that is not what the Jones parties are seeking here. The Jones parties issued a formal subpoena for the documents, and Case agreed to produce the materials so as not to violate any directive of the court. The Jones parties are now moving to compel the production of the documents. Thus, although there's nothing that would prohibit the Jones parties from asking Case to voluntarily share the document at issue, what the Jones parties cannot do is issue an untimely subpoena without court permission and then ask the court to enforce that subpoena without a demonstration of good cause. So she could potentially voluntarily produce these things to them, kind of like Claire Ayub gave Blake Lively that recording of Steve Sarowitz that she took without his knowledge. Finally, the Jones parties argue that the documents bear directly on Nathan and Wallace's credibility. Case says she prepared the website and social media materials at Nathan and Wallace's direction, while they assert the exact opposite. A party may, under certain circumstances, issue a trial subpoena after the close of discovery when it intends to use the documents it's requested for cross-examination and impeachment only. The Jones parties have not framed the subpoena as a trial subpoena, nor have they indicated that it's for cross-examination and impeachment purposes only. The court does not address that issue. The motion to compel is denied. All right, guys, that's all I got for you for now. But I do have 4 days off of work. Saturday, I'm going to go to the game out in Gainesville. But I'm going to have some time to work on a few things. So hopefully I'll have some more stuff up tonight and tomorrow for you. I'll let you know. Thanks.